Hi, my name is Sean Sukumar. I'm an attorney at Price Benowitz Law Offices in Washington, D.C. One of the more common kinds of drug cases that I see are cases where a person is alleged to have the intent to distribute or sell drugs as opposed to simply being in possession of them for their own personal use. These charges are referred to as possession with intent to distribute and are almost always considered to be a felony charge in Washington, D.C. The only exception to that is possession with intent to distribute marijuana, which, if a person is in possession of under half a pound of drug product in those cases, is considered to be a misdemeanor in Washington, D.C. But aside from the misdemeanor marijuana possession with intent to distribute charge, every other intent to distribute charge is considered to be a felony. The requirements that a prosecutor would need to prove in order to be able to convict a person of possession with intent to distribute of a drug are that you need to be in possession of that product either on your person or in constructive possession, meaning that you are in a position to be able to control and have knowledge of a drug that is not necessarily on your person. So possession is the first thing that a prosecutor would need to prove, either through actual or constructive possession. The second element that they would need to prove is that your intent was to distribute, sell, or somehow share the drug product that you had. This can be done through very circumstantial evidence because in most of these cases they don't actually have you directly selling or distributing some drug to another person. Possession with intent to distribute charges can be very serious in Washington, D.C. There can be felony cases that can result in years of jail time. It's important to have a skilled and knowledgeable defense attorney to help develop the best defense strategy, including both legal defenses and mitigation that can help reduce the possible penalties that you may face.